So the next speaker for the day is Mr. Fola Alade. We are honored to welcome you, sir. He is a distinguished notary public and a leading figure in Africa's area landscape. He is the founder and principal partner of FOTEFA Partners LP and the visionary behind the Mediation Academy of the same, where he has significantly advanced area practice and education. Mr. Fola serves as a global mediator with the United Nations and holds numerous prestigious appointments across Nigeria's legal and area institutions. Renowned for his dynamic training style and thought leadership, he continues to shape the future of dispute resolution through mentorship and innovation. We invite Mr. Fola to address the gathering and share his valuable perspectives on the domain of ADR in Nigeria. Uh, Over to you, sir.
Yeah, thank you so much, Shakti. I'm audible. Can you hear me?
Yes, sir.
Awesome. Yeah, I'm truly honored to be here with everyone. So I remember when Imba reached out to me to speak on international on ADR specific reference to arbitration. I told him, I said, Imba, I'm a mediator. I'm a full-blooded mediator. I said I eat, drink, and sleep mediation, but I will be happy to speak on your platform because I believe that if we all call ourselves ADR practitioners, we all should be able to work together. And my starting point really would be on this note. I have this implicit belief that arbitration, ADR, the approach to ADR should be more like some kind of trajectory. And when I'm talking about trajectory, what do I mean? When disputes arise, we should start off with negotiation. If negotiation fails, we try mediation. If mediation fails, then we then try arbitration. I believe if we all work together and adopt this procedure, we'll find an enabling environment that will be very, very dispute friendly to practitioners. So on that note, I will be talking about today's paper. I was told to speak about the role of Nigerian parties as stakeholders in international mediation. So I think the starting point really should be this. Why does Nigeria matter in global mediation? Why are we having conversations about the infusion of Nigeria into global mediation? Ladies and gentlemen, Nigeria is not only Africa's most populous country and largest not only the most populous country and largest economy, it also plays a very significant role in regional commerce. And as global disputes have become more complex, Nigeria's participation in mediation, not only arbitration, is critical for regional and global stability. Now, I think at this point, I should also talk about the population of Nigeria as I speak right now. Nigeria has over 200 million growing population. Now, thanks to technology, I dare say that the world is already flat now because I'm here in Nigeria. I'm having conversations with practitioners and attendees from all over the world. Now, the infusion of technology into what it is that we do right now has also significantly increased engagement in cross-border transactions. Now, most commercial transactions are now beginning to have the tripartite dispute resolution clause that talks about negotiation, that talks about mediation, and eventually talks about arbitration. Now, these clauses are also being included in tech, construction, and energy. Now, the significant impact of what is happening right now has also helped in some legal and institutional foundations. Now, Nigeria has also enacted the AMA, which is the long form of Arbitration and Mediation Act, which now formally recognizes mediation as a standalone process. Now, because of this, we are now beginning to have strong institutional presence in Lagos, Abuja, and other states in Nigeria. Multi-door courthouses are springing up. Private mediation centers are now springing up. And interestingly enough, the Nigerian courts are now beginning to not only support but enforce mediated settlement agreements to the effect that agreements that have been settled are then adopted as consent judgment between parties. Please permit me to just talk about some of the key highlights of the Nigerian Arbitration and Mediation Act. I'll speak to section 67 sub 1, which ties into today's topics and talks about how the law would apply to not only domestic but international commercial mediation proceedings. So what this invariably means, ladies and gentlemen, is that if Nigeria enters into any commercial transaction with any country and there's a dispute at all, the enforcement can be applied to not only domestic but international settlements. It would also interest you all to know that Section 73 sub 5 of AMA also gives preeminence to online dispute resolution. So the era of having to leave one point to go to another point has been replaced with you virtually mediating from the comfort of your homes. And this law also provides that the parties can conduct the mediation sessions through any electronic means that is available to them. Now, interestingly enough, the growth of ADR with specific reference to mediation in Nigeria is in leaps and bounds. Now, thanks to ADR evolving into ODR, the technology landscape in Nigeria is changing. You know, people seem to be embracing mediation more because of the convenience, because of the ease, and because of the speed. And Section 73 sub 6 of AMA also provides that an agreement that with the agreement of parties, a mediator can also make proposals towards settlement, but has no right to impose settlement on the parties. Now, Section 77 also talks about the fact that information in any form which comes out of a mediation session cannot be used as evidence in any arbitral, judicial, or administrative proceedings. And Section 81 provides mediators with immunity to the effect that mediators cannot be brought to court to talk about any mediation sessions or be held liable in the discharge of their duties unless it has been shown that the mediator has exhibited an element of bad faith. Now, for me, Section 82 sub 2 of AMA seems to be the most significant of all, as it has finally laid to rest the misconceived and the wrong assumption that mediation is not binding. So we can now say that mediation is not only binding, but it is enforceable as a contract. We all know, as a consent judgment, rather, we all know that the end product of a successful mediation settlement is an agreement. That agreement in itself is a contract. So with the infusion of Section 82 sub 2, it invariably states that that particular agreement can be adopted as consent judgment. Now, Section 87 of AMA is not any different from the Singapore Convention on Mediation that we'll be talking about, which essentially states that international settlement agreements are enforceable in Nigeria and the laws of the convention resulting from mediation. Now, to also give further credence to the framework and the geometric progress mediation is making in the global space, we have the Lagos Multi-Door Courthouse, which was a concept that was initiated by the NCMG. Now, please permit me to just give a bit of context into the multi-door courthouse here in Nigeria. Aside from the fact that the multi-door courthouse is the first of its kind in Africa, the concept was first of all brought about by Harvard professor Frank Sander. And essentially what he proposed was a concept of having a court with a multi-door. And the analogy I would use is you just having a building that have so many doors. So the implication is that when there's a dispute that arises, there's a framework of trying to see whether in that same place that dispute can be resolved through negotiation. If negotiation fails, you try mediation. If mediation fails, you try arbitration. So that way, you're able to provide disputants with multiplicity of options. Now, this inspiration was actually was replicated in Nigeria by Kehinde Aino, senior advocate of Nigeria, and it was eventually launched in Africa in 2002. Now, the way cases are being referred to mediation at the Lagos Multi-Door Courthouse are in three ways. It could actually do it through the walk-in, where the parties walk into the multi-door courthouse to initiate a suit, or they can actually have court referred. Now, this one is actually very popular. So for cases that are in court, the judge can exercise his discretion to have the case referred to mediation. But mind you, that is all the judge can do. Parties cannot be compelled to settle, but they will be told to see whether there can be available means towards ways the dispute can be settled. And of course, we have the direct intervention, where the LMDC director can look at certain cases in the issue of public interest and then decide to come in to resolve the dispute amicably. Now, still within the framework of this, we also have the Singapore Convention on Mediation, to which Nigeria is the 13th, which was ratified in 2023, and Nigeria is a signatory to it. So the implication of this is that countries that have been ratified or signed the Singapore Convention can do international, when disputes arise, the international settlement agreements with coming out of it can be enforced in it. So all of this, ladies and gentlemen, is all happening almost all at the same time. AMA coming out in 2023, and Nigeria being ratified in 2023. And some of the benefits of Nigeria that has come from the ratification of the Singapore Convention is this. We first of all have enhanced dispute resolution mechanisms. Businesses and individuals in Nigeria can also leverage extensively on mediation as a way of having disputes resolved. Now, we're also having increased foreign investment. Now, one of the downsides that has been some kind of stumbling block to foreign investments in Nigeria basically has to do with the fact that when disputes arise, would they be in court for years without end? But with the infusion of mediation into the global scheme of things, more companies are coming into Nigeria. The business environment is more favorable, and it's also attracting foreign investors. And of course, we all know that the language of the 21st century is speed. So and this is one of the frameworks of mediation. You have cost and time efficiency, and most importantly, it's also very accessible to international markets. Now, of course, we cannot um, do justice to this conversation without looking at some of the cases that have been brought about, some of the cases against mediation, is the fact that for as long as there is a delay on one side, there's a delay always favors one side. There's always one side of the party that wants the case to spend longer years in court. And apart from this again, is also this misconceived notion of the non-bindingness of mediation. People still believing that mediation is not binding. So a lot of awareness needs to be done. And because people are so used to having things done in a particular way, they don't seem to see some of the benefits of mediation. And I dare say that some lawyers too are also not also helping the narrative. They still believe that, oh, if any case comes up, rather than us embracing ADR, we should still try and see how we can go to court to have issues slugged out. Now, of course, parties cannot be compelled to participate except when they are ordered by the court. So the principle of voluntariness can be a sword and can also as well be a shield. So parties cannot be compelled to mediate. And of course, for there to be a successful mediation, there has to be the cooperation of both sides. And if the parties involved in mediation are not willing to compromise, there is no way the process cannot end in failure. But having said all of this, let's talk about the opportunities ahead in terms of the role Nigeria is playing in global mediation. There's a need for Nigeria to also leverage a common base for harmonization with international ADR standards. There's also a need for us to also position ourselves as a neutral seat for not only cross-border mediation in West Africa, but collaboration with global ADR bodies for training, accreditation, and development. And of course, this is also coming into areas of industry-specific mediation. We are beginning to have organizations coming up saying that, you know what, we don't have that much time to spend in court. Can we have issues? Can this dispute be resolved effectively and quick? And because Nigeria has been well positioned to become a leader in international mediation from the global south, critical steps are being taken to include not only institutional strengthening, but legal clarity, intentional alignments, and strategic education. This we can see from conversations that are going around the subject surrounding ADR with specific reference to mediation. Now, in rounding up, I would like to speak about, I would like to end with this picture here, which is a toolbox that states that when disputes arise, I know I said it the first time, but it's also important I rehash it, that one way of having disputes resolved should not be the first port of call. There should be some kind of trajectory. We try negotiation. If negotiation fails, we look at mediation. If mediation fails, we look at arbitration. And I also belong to the school of thought that the rate at which the ecosystem of dispute is changing. Should we still be referring to ADR as an alternative? Should ADR still be seen as an alternative to litigation? Or rather, shouldn't it even be seen as an appropriate dispute resolution that provides various ways and manners in which disputes can be resolved? And on this note, ladies and gentlemen, I end my session. And then one of the reasons why I decided to do this was to leave enough time for questions, as I believe that engagement is the strength of clarity. Thank you. So Imba, I think I'm done. I told you I was not going to go beyond 15 minutes.
Thank you, Fola. Anyway, the insight as you shared with us on the mediation, particularly international mediation, and the way Nigerian jurisdiction has facilitated the new Arbitration and Mediation Act. I presume, hope I am right on it.
Yes, you are.
This is a good try, similar to the Indian subcontinent. For your information, in India, we have this legislation or the act titled as Arbitration and Conciliation Act. This is an interesting legislation, traditionally using the word conciliation instead of mediation. And it has facilitated since 1996 in India till the recent legislation of Mediation Act 2023. Being such a development which happened in India, we had a bifurcation of these mediation in the context of court annexed, that is the court referred,
Yes.
then the agreement-based mediation, then we have the institutional mediation, and as a substitution, we have the community mediation and online mediation. These are the very interesting development, not taken from the Singapore protocol, but traditionally what was happening the Indian subcontinent. In the morning, there was a speaker, Indian origin speaker in US, practicing in US. He comes from a particular province in India, which is called Gujarat, wherein that state, as an innovative idea, brought in this court-referred mediation, made it to be a pre-institutional process. Before starting arbitration or before even taking the issues or the disputes to the court registry would eventually refer the matter to mediation. So much of development we have seen in a contemporary period regarding mediation in the Indian subcontinent. That is very, very interesting for us to share with you. And the Nigerian model also happened to be on that same line. And as a participant, we are very interested to hear a different perspective of Nigerian ADR, one pertaining to arbitration, another about mediation, being complementing the ADR scenario in the West African nation. And thanks, Fola, for sharing the insight. And as rightly highlighted, international mediation, particularly on the commercial disputes, would be the future. Thank you. Thank you very much.
Yeah, thanks so much, Imba. So honored to be here. Thank you very much.